I'm really just absolutely thrilled to be able to welcome Emeritus Professor Rosalind Croucher, AM, to present to us on a new national human rights framework for Australia. As you're all aware, the Human Rights Commission is reaching the conclusion of its very major project, the Free and Equal project. And they've been identifying and inquiring into a national system for protecting human rights, what that should be in Australia. And in this talk, Rosalind will share with us the Commission's vision for a new human rights framework at the national level, and the centrepiece of that framework, which would be a new Human Rights Act for Australia. So Emeritus Professor Rosalind Croucher, AM, was appointed the President of the Australian Human Rights Commission in July 2017. And now she has spent time since then doing a wealth, a great breadth and depth of work in all sorts of dimensions of human rights practice and law. In 2014, Professor Croucher was acknowledged for her contributions to public policy as one of Australia's top 100 women of influence. I think she should actually be higher up than the top 100. Rosalind, I think we could do better. And also awarded the Australian Women Lawyers Award. In the Australian Day Honours list in 2015, Professor Croucher was made member of the Order of Australia. She was conferred by Macquarie University the title of Emeritus Professor in 2016. 2018, UNSW conferred on her an honorary Doctorate of Laws. There's too many more things for me to add, and I don't actually want to detract from any more time spent with me introducing. So, Professor Croucher, I'd like to welcome you to our conference again. We're very pleased to have you, and I'll hand over to you for your remarks.
Welcome and hello to everybody in the room. I am indebted to you, Melissa, and the wonderful Castan Centre for inviting me once again to your fabulous conference. And I'm also delighted that Dean Brian Horrigan, who opened proceedings this morning, is an esteemed colleague and, well, former colleague, but also in the Dean's world, an eminent person that I acknowledge as well. And of course, coming after me, apart from our esteemed chair, Melissa, is Julie Deviljack and the stellar panellists to follow. And concluding the day with Dr. Alice Edwards, who's being roused from her slumbers to present. I had the great pleasure and privilege of meeting Alice in Geneva in March. So I'd like to begin my presentation by acknowledging the traditional custodians of the land on which we're meeting today, Wurundjeri country. I'm on Gadigal land in Sydney, and pay my respects to elders past, present and emerging, and of course to acknowledge any First Peoples attending today. I speak to you at a critical time for the protection of human rights in Australia. Later this year, Australians will go to a referendum to consider whether a voice to Parliament should be added to our Constitution. This is something that the Australian Human Rights Commission supports and which we see as contributing to the better implementation of human rights of Aboriginal and Torres Strait Islander peoples. And next year, we will have a generational opportunity to secure a Federal Human Rights Act and begin the task of modernising our out-of-date legal and policy framework for the protection of human rights. For the past 4 years, the Commission has been undertaking a project called Free and Equal, an Australian conversation on human rights, in which we have asked what would make an effective system for the protection of human rights in Australia. From 2019 to 2021, we released an issues paper and 3 discussion papers, conducted a submissions process, receiving approximately 160 submissions. We held a spectacular national conference on human rights and other workshops with the United Nations High Commissioner for Human Rights, and conducted a series of roundtables, technical workshops and stakeholder consultations. It's been an extensive consultative process. And I should also acknowledge that we build on and complement the extraordinary work that so many of you in this room have led or participated in, and indeed the fantastic work of the Castancentre itself. I spoke at the Castancentre conference about the project at its beginning in aspirational terms. And since then, our aspirations have landed in terms of 2 position papers on key reform priorities. The first position paper was released in December 2021, which was a reform agenda for federal discrimination laws. In this, we set out an ambitious reform agenda to modernise our federal discrimination laws, including by remedying deficiencies in the current laws, by placing a greater focus on prevention of discrimination, and by introducing co-regulatory approaches that enable governments and businesses in particular to be better equipped to prevent and deal with discrimination. These laws are out of date and not serving the Australian people as well as they could. And in those recommendations, we build around and build on the work in the sex discrimination arena led by the previous Sex Discrimination Commissioner, Kate Jenkins. But as we all know, addressing discrimination alone is not enough to ensure that people's human rights are protected. And so in March this year, we launched our second position paper, A Human Rights Act for Australia. It is designed to complement protections against discrimination and deal proactively with issues that discrimination laws cannot address. It presents our case for the introduction of a Federal Human Rights Act in Australia and an outline of our proposed model and associated reforms. It seeks to complete the central missing piece of our domestic legal framework for the promotion and protection of human rights in Australia by bringing rights home. Just after we launched our paper, the Attorney General referred to the Joint Parliamentary Committee on Human Rights an inquiry into a human rights framework for Australia, with express reference to our proposal for a Federal Human Rights Act. The PJCHR will report in March next year. Since June, so just a month ago, we have made 2 submissions to that inquiry. The first submission provided an overview of the key findings of the Free and Equal project to date, and then set out our vision for a new national human rights framework featuring a Human Rights Act at its centre. Our second submission, which has yet to be loaded on the PJCHR website as at yesterday, complemented this submission with illustrations of how a Human Rights Act might make a difference, drawing from examples of Human Rights Act jurisdictions, such as Victoria, and where the absence of a Human Rights Act in other states, territories, and the federal level exposes weaknesses in our existing human rights protections. Our proposal for a new human rights framework for Australia sets out 5 key pillars and 3 supporting foundations. The foundations necessary to support the effectiveness of the framework are human rights education, 2, a sustainable Australian Human Rights Commission, and thirdly, a vibrant civil society to protect human rights. The 5 pillars of the framework are these. Number 1, comprehensive and effective protection of human rights in legislation through the introduction of a National Human Rights Act. Number 2, federal discrimination laws to be modernised to ensure their effectiveness and to shift the focus from a reactive model that responds to discriminatory treatment to a proactive model that seeks to prevent discriminatory treatment in the first place. Number 3, the role of Parliament in protecting human rights is strengthened through reform to the processes for parliamentary scrutiny and the introduction of new oversight mechanisms for Australia's human rights obligations. Our 4th pillar, a National Human Rights Indicator Index, is introduced to independently measure progress on human rights over time. And 5thly, an annual statement to Parliament on human rights priorities is to be made by the government. Each of these elements, the 3 foundations and 5 pillars, each of these elements has a role to play in an integrated human rights framework. Why do we need this? There is currently an implementation gap between the human rights standards that Australia has agreed to internationally, our promises to the world, and the actual protections in our laws, policies, and processes of government. Our Constitution protects some rights through the limitations on the power of the federal parliament to pass legislation, but it does not confer rights on individuals. The common law principle of legality helps in interpreting legislation in a way that is consistent with fundamental rights to a point. And the parliamentary scrutiny of legislation plays an important role. But like the Commission itself, the PJCHR and other scrutiny processes are hampered by the fact that its legislative reference point does not sit in domestic law. The existing mechanisms are just insufficient and do not provide the human rights protections that all people in Australia are entitled to. Without comprehensive legal protection, education, and other measures to promote an understanding of human rights and the processes for monitoring compliance with human rights, Australia is not fully meeting its obligations to ensure that the human rights of all Australians are respected, protected, and fulfilled. Our experience with royal commissions into robo-debt and the abuse experienced by persons with disability and in aged care have exposed egregious human rights breaches and show how our existing systems are just not adequate. The experiences during COVID-19 also reinforced the need for greater protection of human rights and more finely tuned and proportionate considerations up front in the policy-making process. The need for better human rights protections in Australia can be summarised by one simple proposition. We should have proper protection of human rights at the national level because everybody's human rights matter all of the time. A primary benefit of a national human rights framework is that it will foster a culture of respect for human rights throughout the whole of government and across the country. It would likely contribute to a better understanding and awareness of Australia's human rights obligations, increasing acceptance of them, and provide greater prominence to human rights through the demonstration of political will by the government and the Parliament. It would provide the foundation for and enhance what I call rights-mindedness in policy, law, and decision-making. Parliamentarians and public officials should be required to consider the human rights impact of their actions. and they should be required to favour options that positively protect human rights and justify that their chosen actions cause the least possible harm to people's rights. To achieve this, we need a Human Rights Act. The Australian Human Rights Commission has been handling human rights complaints since 1981 through the lens of the international treaties. We seek to resolve complaints about breaches of human rights through conciliation. This is distinct from our jurisdiction to conciliate unlawful discrimination complaints under the 4 federal discrimination laws. However, unlike that pathway, people who complain that their human rights have been breached cannot obtain enforceable remedies through the courts. This seriously limits the effectiveness of conciliation about such matters and the willingness of public authorities to engage. A Human Rights Act, by contrast, in our model, includes the possibility of court proceedings. Without it, you do not get the accountability leverage you need for improving decision-making. But litigation is not the point. It is the positive duty on public authorities to get it right in the first place by developing policies and framing decisions through the lens of human rights. Failures to protect human rights can affect all kinds of people, and any lack of respect for human rights degrades society at large. And those most harmed by human rights breaches are regularly the most vulnerable among us. Just look at robo-debt, the punitive parents' next scheme, and the experiences of people with disability exposed in the Disability Royal Commission. A Human Rights Act would build on the experience of our complaint handling of 40+ years and address the weaknesses of the current scheme. By providing a pathway to enforceable remedies, a Human Rights Act would substantially improve access to justice and accountability for government decision-making. It would provide a greater incentive to think about human rights early, when decisions are made, and before they become complaints. Moreover, it would be an evolution, not a revolution, in our ability to handle and respond to complaints. The Commission's position paper on a Human Rights Act offers a clear and concrete set of proposals for a federal model. It is tailored to the unique legal framework at the federal level. It retains and emphasises the supremacy of the Parliament and is respectful of our constitutional constraints and federal structure. It is based on a positive duty on public authorities to act compatibly with human rights and consider human rights when making decisions, as exists in the State and Territory Human Rights Acts, but also expanded duties to ensure the effective participation of Indigenous peoples, persons with disability, and children, and to ensure equal access to justice. Our model is based on enhanced parliamentary scrutiny. It is based on a comprehensive implementation of human rights across the ICCPR and the International Covenant on Economic, Social and Cultural Rights. It is based on interpretive provisions that align the understanding of human rights to the international jurisprudence, and it is based on the existence of remedial pathways at the Commission, in administrative law and the courts. The beauty of a Human Rights Act and other measures that front-load rights-mindedness is that they are expressed in the positive, they are embedded in decision-making, and they are ahead of any dispute, providing a way of resolving intersections between rights through a proportionality framework. A Human Rights Act names rights, it provides an obligation to consider them, and a process by which to do it, together supporting a cultural shift towards rights-mindedness becoming part of the national psyche and not just an afterthought. We look forward to the PJCHR inquiry to explore the issues raised by the Commission for discrimination law reform, for the introduction of a National Human Rights Act, and for the introduction of other reforms that will assist in measuring our human rights performance and holding government to account for its own performance. The submissions to the PJCHR inquiry are being loaded incrementally on the committee's website, and they are fascinating to read. Of the approximately 150 submissions available to date, there is broad approval of the Commission's overall approach in relation to our model for a National Human Rights Framework and also for a National Human Rights Act. Some submissions would like some elements of our Human Rights Act to go further. For example, by advocating for broader protections, particularly in the area of economic, cultural and social rights. Some are concerned about the scope of protection for freedom of religion and its intersection with other rights. The Commission has recommended that the PJCHR adopt a National Human Rights Act and that it should propose a draft exposure bill to be released for comment based on our model. So the suggestions around the scope of our model, whether it should go further, different areas and so on, can be captured, I would suggest, in the forward momentum of discussion around an exposure draft human rights bill, the top of the wish list for the implementation department. So how does our model, Human Rights Act, compare to the others, particularly in the Australian context? Our model is specifically tailored to the constitutional challenges in Australia, but notably, it goes further than the state and territory models in important respects. In relation to, firstly, the cause of action, in our view, a direct cause of action is an essential plank of the Human Rights Act, not a piggyback claim, but a direct claim. In early 2019, I had the opportunity to speak with Lady Hale, then Chief Justice of the United Kingdom's Supreme Court, about her experiences with the UK's Human Rights Act over 20 years. Lady Hale considered the existence of a cause of action one of the essential pillars of the effectiveness of the UK Act. A direct cause of action has also been adopted in the ACT, New Zealand and Canada. The ACT's provision is modelled on the UK one. In addition to a direct cause of action, our model also enables the raising of Human Rights Act rights in the context of another legal proceedings. Having human rights issues may also be relevant to a range of issues, discrimination, tort claims and criminal-like claims, and they are often raised collaterally. This approach enables flexibility for litigants and reflects the practical reality that most cases are not pure human rights ones. All Australian jurisdictions with Human Rights Acts enable human rights to be raised alongside other claims. However, Queensland and Victoria remain international outliers by only allowing human rights to be raised alongside other claims, the piggyback model. In these jurisdictions, a person can only raise human rights before a court by piggybacking on separate proceedings against a public authority. The 2015 Victorian Charter Review recommended that Victoria adopt a direct cause of action modelled on the ACT approach. These problems have been raised regularly since the introduction of the Charter and were echoed in the stakeholders to our inquiry. And fears about opening floodgates to litigation through a direct cause of action, frankly, have proved unwarranted in other jurisdictions. Additionally, an accessible complaints process utilising alternative dispute resolution would reduce the impact of a Human Rights Act on the judicial system. Litigation need not be the only port of call for people who wish to make a complaint alleging a breach of human rights. Rather, it is a necessary last resort when other avenues have failed. And as I remarked earlier, without a cause of action element, you lack the leverage that you need in your arguments and interventions with public authorities. And when it comes to remedies, our model suggests an open remedial framework. In the UK and the ACT, courts can grant the relief that's considered appropriate. The UK clause limits access to damages, and the ACT provision excludes damages as a remedy where a person alleges a breach of the ACT Human Rights Act. Monetary damages are currently available in the federal discrimination law context, including when the breaches are by public authorities. They're available in the UK, New Zealand, and Canada. The Human Rights Acts in the ACT, Victoria, and Queensland do not permit the recovery of damages where a breach of human rights has been found. The bottom line is that our current state and territory models are outliers again for not making damages available where breaches have occurred. The reason for excluding access to monetary damages was supposedly to avoid litigation and costs for government. But jurisdictions which have a direct cause of action and monetary damages have just not seen the floodgates problem that is anticipated through such nervous concerns. The remedies provision that we have advocated for should ensure that monetary damages are an available option, as is the case in relation to unlawful discrimination. And if we're going to speak about cost to government, just look at the costs of royal commissions. They're the ones that you want to avoid. It's been estimated, for example, that the Royal Commission into Aged Care cost over at least 100 million. The Royal Commission in relation to people with disability has been estimated to cost over $500 million. Failing to provide sufficient remedies means we breach our international human rights obligations. And if we're concerned about costs, I would urge, make the true comparison, the costs engendered by royal commissions, and that's for egregious human rights abuses that have been exposed long after the damage has been done. The right to claim monetary damages for a breach of human rights would send an important message to public authorities, people in Australia and the international community. And of course, the Human Rights Act could also attract a range of administrative law remedies that are currently available. In relation to conciliation, I've mentioned earlier the fact that our model is an evolution, not a revolution. Just as I'm very conscious of the time, I think I might just go to my concluding remarks with a call to action, because I know our esteemed panelists will go there in so many levels of detail. They are a brilliant group, and I'm going to watch with great interest. So I will conclude my remarks with a call to action. The reality is that our legal framework for protecting human rights in Australia and for the prevention of discrimination has changed very little in a generation. The introduction of a positive duty for some grounds under the Sex Discrimination Act, but not others, is a notable exception to this inertia, but it's still limited. Very little of the human rights framework that was introduced as a response to the Brennan National Human Rights Consultation in 2009 has endured. And we are left with a passive system of rights protections, where the protection against discrimination relies on individual complainants bringing action when they have experienced harm, instead of proactive measures focused on prevention and building a culture of respect, where the protection against human rights violations by the federal government through the Commission's human rights existing jurisdiction is mostly without consequence. It's passive where there is a lack of transparency about how government addresses known human rights concerns, such as the issues raised repeatedly by treaty body committees and through individual communication processes. It's passive where there is an absence of benchmarks and targets against which to regularly hold government to account for progress in protecting human rights. And it is passive where there is a serious absence of measures to educate the community about human rights or to ensure that public servants see the protection of the rights of people in Australia as their core business. This has to change. Not another robo-debt Royal Commission. Government is here to improve the lives of everyone in Australia. The impact of government decision-making on the well-being of the community that they serve should be top of mind all of the time. And our conversation about human rights should be positive, ambitiously focused about what government should be doing to ensure that we all have the opportunity to thrive and develop, free from discrimination, and with our full human dignity respected and protected. Please join us in advocating for a new national human rights framework and for robust legal protections at the national level. Thank you, Melissa, and I will hand back to you and to such a wonderful panel to follow.
My goodness, thank you so much, Emeritus Professor Rosalind Croucher, for your amazing vision and just seeing the way that you've transferred from where we met last time in this forum and with your aspiration, and now how this is crystallised and the plans that we have before us. It's very, very impressive. So I'm very, very grateful on behalf of our audience to hear from you with your impassioned and very comprehensive explanation of the Commission's work. We're very, very grateful.